Good evening, everyone. I'm going to ask Ernie if he'll join me by turning his camera on. I want to welcome everyone to tonight's town hall. This is the fourth in the series of Seeking Justice. Tonight's topic is Justice Beyond the Verdict and why Shelby County needs a Conviction Review Unit, or CRU. We're here tonight because the topic of criminal justice reform is so critical in our country. Here in the United States, we have 4.2% of the world's population, and yet we have 20% of the world's incarcerated population. That means that between 1 in 4 and 1 in 5 of the entire world's incarcerated population is here in the United States. And I think it's so important that if we're going to be this country that believes in mass incarceration and who believes in that punitive system of justice, that we're also a country that believes in getting it right. I want to give you a quick quote from a gentleman who was freed after 30 years of incarceration for a murder he didn't commit. Hugh Burton served 30 years. He was locked up in 1991 for a murder that he didn't commit, and a Conviction Integrity Unit, which is another Conviction Review Unit, and not the Tennessee Innocence Project, but the Innocence Project were instrumental in seeing to his release. And he gave us a quote in the midst of when he spoke out after he had been released, and he said something to all of those who have been locked up for something that they didn't do. My advice to other innocent people in prison is don't stop, don't give up, continue to fight, don't lay down. The moment you lay down, that's when it's over. I want to encourage all of us who are here tonight that when we look at our justice system and when we see people who are incarcerated for a crime that they didn't commit, we need to stand with them. We don't need to lay down. We don't need to give up the fight. And we need to ensure that justice is done. I'm super excited tonight to talk about the Conviction Review Unit. For those of you who don't know what a Conviction Review Unit is, we're so glad you're here, because tonight we're going to learn what a Conviction Review Unit is, how it works, and why we need one. My name is Janice Lee. I'm the Vice President of MICAH, and I'm so glad that Ernie is on the screen with me now. And I just want to welcome everyone to tonight's program. Again, this is our fourth in the Seeking Justice Town Hall series. If you have missed any of the prior town halls, you can find them on MICAH's website under the tab for Seeking Justice. We encourage everyone, as you are watching along tonight, please comment in the chat. If you're watching on Facebook, please add your comments. If you have questions for any of our panelists, please put them in the chat or in the comments, and we will try to get some of them answered toward the end of tonight's program. I also want to ask those of you who are part of a MICAH partner, please put your name and what partner you're representing in the chat so that we can acknowledge and see who of the MICAH partners are here and participating, and also just to welcome those who may not be a part of MICAH but have come in to listen to this important information. Again, welcome, and I'm going to let Ernie tell you what you're in for tonight.
Thank you, Janice. It's my privilege and pleasure to tell you about tonight's topic on conviction review units. And it's my pleasure to also introduce our two panelists, Mr. William E. Arnold, Jr., who is an impacted person, and we'll get to hear from someone who actually lived this, has this lived experience. And I think about you and myself, and wonder if you or anyone you know has ever been accused of anything you did not do, or wrongly accused of something you did not do. How did you feel? How did they make you feel? And here's a young man who was accused, wrongly convicted in 2013 and was finally released in 2020 by an appellate court. So those 7 years of his life were lost. His rights, freedoms, privilege, all taken away. How would you feel? And the other panelist, Ms. Sonny Eaton, who is now the director of the Nashville, Davidson County CRU Conviction Review Units, and she's doing amazing work there. They're just getting started. She'll tell you all about that, but they're really making good track records. And so we're very excited. You can read the full bios and their link. So we'll get started I'll turn it back to Janice.
Thank you. And right before we get ready to kick off, just like you said, there are we have a discussion guide. And some other information. Please lean into that. Look there and see if it will help you follow along. It will give you more facts, more information, and let you dig a little deeper into what you're hearing tonight. Before the panelists come on, and I am so excited. I'm fumbling over my words. I'm so excited. They're wonderful. They're just so incredible. But I want to ask if Reverend Dr. Andre Johnson could just open us in a word of prayer, and then we will go straight to Sonny and William. Thank you again, everybody. Welcome.
Thank you. Thank you for having me and inviting me, and thank you for convening this important discussion tonight. And thank you all who are part of the Zoom room, as well as those who are watching on social media right now. Let us pray. Gracious God and our Lord, we come thanking you for tonight. Thanking you that you have brought us together, that you have touched us profoundly in many different ways, that you have manifested your glory in us, through us. We have shared that love and appreciation with others. Now, Lord, we ask that you be with us as we gather to talk about an important subject tonight. We pray for our leaders. We pray for those who are making decisions that would directly affect us. We ask now that you will lift us with your love and grab us with your grace, that you will move in a miraculous way. May you pour forth your spirit on this city, this county, this state, this country, indeed this world. May we see it, may we feel it, may we hear it, may we embrace it, and may we be the people that you have called us to be. Hear our prayer tonight, O great one, the one that knows us all by name, the one who shapes and fashions and forms us, the one who calls and comforts, the one who pushes and prods, the one that loves and lifts. Hear our prayer tonight. Hear our prayer. It is in your name we say together, amen and amen.
Thank you, Reverend Dr. Andre E. Johnson. And now I'm just going to ask Sonny and William if y'all will go ahead and turn on your cameras. I look forward to hearing William's story and then learning more about CRUs.
Please take it away, guests. Please take it away.
Good evening. Can everybody hear me? I wasn't sure if I was scheduled to start first or not. My apologies. My name is William Arnold, and I'm a native of Memphis, Tennessee, and what I like to say is a proud product of the Memphis City school system. After growing up in Memphis and attending high school, I moved to Knoxville went to college, and after college, I actually went to the University of Tennessee State University, where I received graduate degrees. I'm seeing in the chat that people can't hear me. Okay, I'm not sure what to do here. I'll start over. If Sonny could go ahead and start, and I'll figure out what's going on. I'm sorry.
No problem. Can everybody hear me okay? Perfect. I'm pretty loud, so I should be able to compensate for any sound problems. Sorry for the silence. I wasn't exactly sure who was supposed to go first, and I think it's important that we hear from William to give context to this work. I am also long-winded and didn't want to take up all of our time, but I will give him a chance to figure out his sound. My name is Sonny Eaton. I'm director of the Conviction Review Unit in Nashville, Tennessee. I have been in that position since September of 2020. Our unit began around 2018. It's been reported anywhere from 2016 to 2019 when we began, but I believe it was officially 2018. There was some pre-work that needs to be done to begin a unit like this. I think it is highly underestimated what goes into implementing a conviction review unit. So let me start with that. Let me start with what a conviction review unit is. It is very unique. And although they're growing rapidly, there are still very few of these in the country compared to the number of district attorney's offices that there are in the country. And a conviction review unit, by definition, is an arm of a district attorney's office. So first thing, if you hear anyone out there telling you that this is something that should be independent or there should be an independent agency, those things can exist and maybe should, but those are not conviction review units. A conviction review unit, by definition, is something that exists within a district attorney's office. It's not an invention of Nashville, Tennessee. Although the Nashville office was the first one in Tennessee and one of the first in the South. This actually started in Dallas several years ago. They were the first unit to get going. They had tremendous success, and their model spread to many other units. We've seen some incredibly successful units in various arms of the country: Baltimore, Philadelphia, Brooklyn. What a conviction review unit is a little bit different per office, but there are some pretty basic tenets that make a unit effective. And I say that carefully because simply having a conviction review unit isn't quite enough. You also have to have an effective conviction review unit. I'm not quite as harsh in my analysis of what makes an effective conviction review unit as some people are. And when I say that, a lot of people judge that on how many exonerations a unit has had, but it's not quite that simple. A unit could operate for several years before having an exoneration and still be incredibly effective. Now, when I say what makes an effective conviction review unit, in my view, that requires a few things. And one is independence. I only report to our elected district attorney. I don't have any other reports in the office. I stay relatively separated from the rest of the office, though not so separated that I can't be part of culture change within the office and be part of prevention and training. But separate enough where I am not biased by working with the same prosecutors who handled some of the cases that I look at every single day. Second, I don't prosecute any cases. No one on my unit prosecutes any criminal court cases, and I, as the director, don't prosecute any cases at all. If you ask me my title, it is director and assistant district attorney, but it is not prosecutor. Now, that's not the same for every office. Some offices still call their CRU attorneys prosecutors. That's semantics, but to me, it's important that I make the distinction, particularly since in Tennessee, this is relatively new, and I'm trying to make people understand that what I do does not involve prosecuting cases. The reason that matters comes down to something that we'll talk about as the night goes on, which is bias and perspective. Lawyers are trained to do a thing. That's what we're trained to do. We are trained to take a side and aggressively argue that side. We're trained to have a perspective. And I believe it is very difficult for a lawyer who serves in a prosecutorial capacity to step back from that into what I do, which is looking for innocence, which is a different perspective altogether. Now, those are two of the most important things that I believe make it a conviction review unit effective: independence and some separation from the rest of the office, combined with also not having prosecuting attorneys running the unit. What we do is get applications from a variety of sources. Sometimes applications are how cases are initiated. Other times cases are self-initiated. Sometimes it is because we've heard about a case, or there is what we call a sentinel event. A sentinel event is something where, for example, a police officer is found to have a pattern of misconduct that may have impacted convictions. That might lead us on our own to go look at past cases from that police officer or a prosecutor. Or it might be related to a new or changing understanding of scientific evidence, or the way that we view scientific evidence, particularly if it's the kind that's been central to past convictions. That might make us as an office self-initiate a review. But typically, reviews are initiated when convicted people themselves reach out to us, either on their own or through an attorney. That process for us exists in multiple stages. The first thing we do is do an initial screen where we just figure out if it's even an innocence claim at all. And that should make me back up, because one thing that's clear about what we do, and every unit is slightly different. Units that have been around longer exist in bigger jurisdictions, maybe more progressive jurisdictions have begun to get into wider application. In Philadelphia, they're doing sentencing review. And I believe they're also doing beyond just actual innocence. In Nashville right now, we are very much looking for actual innocence. And we are looking for actual innocence based on new information that was not presented to a jury. That is very specific. That is not my lawyer didn't do a good job. That's not a search warrant was executed on my house illegally, but in fact, they found what they were looking for. That's very different than actual innocence. Now, that's not to say that we don't look at those factors. We do. We do a holistic review of everything that might have led up to a wrongful conviction, including ineffective assistance of counsel. But central to our investigation has to be new evidence of actual innocence, not presented to a jury. So before we even get into that holistic review, there has to be a central question involving actual innocence. We work very closely with the Tennessee Innocence Project. We also work with the private defense bar. There are a couple of reasons for that. One, our Tennessee Innocence Project is excellent. Frankly, they have incredible lawyers there who are very trustworthy and we have a long relationship with. And there's such volume that it is helpful to work with an agency that has their own vetting process before bringing us cases, and that we have a strong relationship for information sharing. That brings me to another point of what makes an effective conviction review unit. We work very hard at transparency. And that is maybe one of the most important things that makes a conviction review unit essential in a district attorney's office, and in some ways more effective than an outside agency would be. We have access to information that would not be discoverable under any other procedural rule. I have access to what would be considered work product, which would otherwise not be turned over to a defense attorney or to someone seeking records through a public records request. I have access to institutional memory. I can walk down the hall to someone who's been around for 20 years and ask them how something was done back then. I can, as has happened in a case, I can look at a sticky note in a file that has initials on it and walk down the hall and ask someone, do you know whose initials these are? And we've actually had a case turn on that kind of thing. That's the kind of thing that can't happen from an outside agency. So it's incredibly important that there is someone internally doing this work. Out of the cases that we've done in Nashville, many of these cases, more than half, have turned on the type of information that would have only been found within work product or with institutional memory. So I do believe that having this internally, not only is it important, but I also believe that it's essential to any district attorney's office. I think that what we are coming to understand nationwide And certainly what in Nashville, our elected district attorney came to understand quickly is that doing justice and doing the job of a district attorney isn't about just convicting people. It can't be. And even if you look at the most conservative statistics, I believe Innocence Project says anywhere from 2% to 10%. Even if you cut that well in half, even if we're talking about 1% of people who are convicted, even if we're talking about 0.5% of people who are convicted, we're talking about an incredibly large number of people. And what we believe, certainly in Nashville, and I believe in other offices where there are CRUs, is that as a district attorney's office, this is not counterintuitive to our mission. This is not compete with the mission of a district attorney's office. District attorney's offices have a duty first and foremost to victims. But what we cannot ignore and what we have to acknowledge is that when we wrongfully convict people and put them in prison, and even beyond prison, expose them to the collateral consequences that come along with convictions, we are creating new victims. We are affecting lives in a victimizing way. And that creates a duty for us as a district attorney to also help those people, to seek justice for them. And anything less is us not doing our job. Now, I want to circle back and talk a lot more about this and answer a lot of questions, but I really think this is a good time for context. So I'm going to hand this back over to William to tell you his story.
All right. Thank you, Sonny. Is this better? Can you hear me now, Sonny?
I can. You're still a little bit low, but you're better than you were.
Okay, well, good deal. I'm gonna come a bit closer, and hopefully I don't get a little too loud.
Okay, I'm going to come off video while you're talking real quick.
I'm sorry? Okay.
I'm going to come off video while you're talking.
Good deal. So as I said, my name is William Arnold, and I'm a native Memphian. And my story is so interesting. It was one of the first times I was glad I wasn't in Memphis. And I say that because in 2013, I was wrongfully convicted of crimes I didn't commit. And I went to prison. And then in 2014, I filed my first appeal, and that appeal was rejected in 2015. I filed an appeal of that appeal to the state Supreme Court, and I lost that appeal in 2016. So if you can imagine being told no, imagine what it's like being told hell no, and it has to do with your freedom. I was convicted and sentenced to 25 years. So I knew that the only way I could get out of prison was that I had to go through a court system. But what was most important was I knew that it was going to be about faith. So it was in the fall of 2017, I was reading the Tennessean, which is the Nashville newspaper. And interesting enough, I read an article about a conviction review unit that was being started by this new district attorney, Glenn Funk. I remember writing Glenn Funk's office and asking for an application. And when I received it, I can't tell you how happy I was because I saw it as hope. I saw it as hope so much that I felt it was important to give other people hope. And I made copies of that application. And I began to pass them out on the prison yard to people, explaining what the conviction review unit was, because at the time there had been nothing like it in Tennessee. So with that, I filed my application, and I got a response, and the response was interesting. It sort of told me that because I was still going through the appeal for the appellate process, that the conviction review unit at that time could do nothing for me. But it was still hope, because they said at that time, simply because I was going through the process. And so it was in the spring of 2020 that my case was finally overturned on what's called post-conviction appeal. And that meant that I would have to go back to trial and be tried again. But in the meantime, I was allowed freedom. I was allowed to come home. And so in April of 2020, at the height of the pandemic, I was released, ironically during what's called Second Chance Month, when the nation celebrates individuals getting a second chance after leaving incarceration. It was in July of 2020 that my attorney, Patrick McNally, contacted me and told me that the conviction review unit had reached out to him, and they had informed him that through the application and through their investigation, that they were dismissing the charges. So with that, at that point, I was essentially free from these charges totally, and that I knew that I did not have to go back to trial. I did not have to deal, so to speak, with these legal issues at that time, and it was all because of the Conviction Review Unit. And when I think of the Conviction Review Unit and what it does, I mean, it's humane. And I say it's humane in that it is a remedy for humanity. I don't know of anyone who's perfect. And of course, district attorneys are human and they're not perfect. And we all make mistakes in our jobs and in our lives. And so I see the Conviction Review Unit as a way to understand that we are human and we make mistakes, and district attorneys make mistakes. But if we got to truly do the work of criminal justice, and we're truly to do the work of people, it's only humane to acknowledge those mistakes. And as Sonny said, to be transparent in the aspect of we are going to work harder to do better and to be better. Because in this world, we're often so tough on crime that we forget that we're also being tough on people. And that's what this Conviction Review Unit idea does, is that it restores humanity and dignity to those people who've gone through a very traumatizing and dehumanizing situation that you go through when you're in prison. And so with that, I applaud District Attorney Glenn Funk's office for what they're doing, what they've done, and what they continue to do. And for that reason, that's why I started my story by saying this was the first time that I was glad I wasn't in Memphis, because as we all know, there's not a Conviction Review Unit here in Memphis. Give it back to the facilitator.
Sonny, you're muted.
So sorry. William, one thing that you and I have talked about before, and I want to be clear for everyone watching, I was not the director of the Conviction Review Unit during the time that William's case came to Nashville. That was Robert Jones. Robert Jones did a tremendous job, of a very difficult job of getting our unit implemented and started. It involved going to a lot of different places and fighting a lot of battles to get us going and get us to be a place of being accepted. And he looked at William's case. But William also had an incredible attorney who got him so far in the process. And to give all of that credit to the CRU would be unfair. But without question, what the CRU did, I believe, William, is speed up the situation. How much longer do you think things might have taken if the CRU hadn't gotten involved at the point of your post-conviction relief?
It's safe to say, first of all, had the CRU not gotten involved, I probably wouldn't be sitting here right now. I'd be somewhere preparing for trial. And with that, because again, as you said, Patrick sped it up, and he was able to get the case overturned in February. Had it not been for the CRU or getting the case overturned, I'd still be sitting there. I mean, it was 25 years.
And for the non-lawyers sitting here, there's only a couple of remedies when you've been convicted, a couple of what we call post-conviction remedies. The first is appeal. That happens in almost every case where there's a conviction. Appellate courts are courts of incredibly limited review. They are confined to the record. They are confined to issues that were raised during trial. There is a world of limitations in an appellate court. And sometimes that's justified. There has to be, but it is very limiting. Beyond that, we have a couple of vehicles, post-conviction relief and a writ of error quorum nobis. And those both have very specific requirements. Also, I should note, the state doesn't have standing to bring either of these things in Tennessee. Tennessee does not give the district attorney's office standing, which is the ability to come to court ourselves and fix our own mistakes. We can't do that. We can't go to court and file something and say, Your Honor, we got it wrong. Now, there is a rule of professional responsibility that says we have to do that, but there's no legal avenue for actually doing it. Rule 3.8 says two things, basically, that if we've lost confidence in a conviction, we have to notify the court. And if we have reason to believe that someone's actually innocent, we have to seek remedy. But there's no legal avenue provided to do that. which is why in Williams' case, and particularly for the first case that a CRU in Tennessee got involved in, it was so critical to the success that his lawyer actually really did the heavy lifting and had such a success with post-conviction, which is rare. It is rare to have this kind of success in post-conviction. But with Williams' case, what's different is typically, even if you win post-conviction, there are several things that can happen. And one of those, which often happens, is that the state decides to retry the case. The court will take into account whatever the issue was, try to remedy that issue, and then it will go back to trial. Now, if you can imagine how long that might take, generally a case in any big city, I don't know how it is in small towns, but in any big city, particularly Nashville, it can take a case a year to 2 years to 3 years from its inception to reach trial. And even in a post-conviction situation, that's no different. This could have dragged on to another trial for another several years. And then there's always the possibility of reconviction. I can't go much into a pending case, but I will say that we have a pending case now where there's been 2 prior jury convictions. So that's not unheard of. And then there still may be post-conviction after those situations. So I think that for William, what would it have felt like to you to win that post-conviction and then have to wait it out and go back to trial?
Sort of like tying in the Super Bowl. You didn't win and you didn't lose. There's still some more stuff to do, right? So that's about the best thing I can give it, because at the time that I learned that my case had been overturned, I knew that I was going home, or at least when the Attorney General made the announcement that they were not going to challenge the appellate court's decision, then I knew I was going home. I didn't know when, I didn't know for how long, but I still knew that there was work to be done. So I came back into the free world not knowing that the conviction review unit was still at work, and not knowing that there was a possibility that the cases would be overturned, or that the charges would not be applied, and that the conviction review unit would dismiss them. So, it was just uncertainty. That's what I felt.
So what's so different about Williams' case than all of the other cases, and frankly, typical cases that we get, is that he had this successful post-conviction effort. That's not typical with the cases that we get. We haven't had that situation yet where what we are doing is simply deciding as an office whether or not to retry something. Now, that's still an in-depth investigation, because remember, we have a duty to the victims who have been told by our office that we believe we have the right person, and a jury has cemented that. So we still have a duty to thoroughly investigate this. So I don't want to make it seem as if that was any small effort. But that is a very different situation than what we've been doing since then. So since that time, what we have been looking at are cases that have been brought to us by either defendants or their attorneys, or self-initiated. About half of those cases, maybe a little over half, have been brought to us by the Tennessee Innocence Project. We work very hard to make this a collaborative investigative process. And I have to say that collaborative process is the most difficult hurdle for all of us to get past mentally, for both the defense and for our office. We're an adversarial system. This is not what we're used to. We're not used to such open sharing of information. Now, in our office, the culture has shifted quite a bit over the last few years, and we have open file discovery in our office now. So we have a generalized policy of sharing everything that can be shared. But that is not the case for most offices by policy. But this collaborative process, it's still very different. And what we are working against is essentially a century of thought about the role of a DA's office, how that role interacts with defendants and with their attorneys. Meanwhile, the way that we do things, very much throughout the investigation, we are communicating with the defense attorneys. We are giving them updates. We're inviting them to do interviews with us. We are sharing recordings of interviews. They're sharing them with us. We enter into a memo of understanding at the outset of a case that kind of lays out the rules for how this will go so that everyone knows what to expect. And defense lawyers have a duty to inform their clients of how this is going to go, because there are risks associated with entering into a conviction review process. A lot of those risks involve ways that the defendant or the defense might interact with the district attorney. For example, if I want to interview a defendant, that is in our memo of understanding that I get to do that. That's not typical in an adversarial process where the DA would get to sit down with the defendant essentially at an ask to do so. Now, I don't do that in every case. And when I do that, in the times that I do, it is usually towards the very end when we are close to the end of a case, close to a decision, and I have specific facts that need answering. Sometimes we may ask for a polygraph. Now, that's a mixed bag. There are reasons to do that. There are reasons not to do that. Some CRUs require it at the outset of a case, and what weight they give that, I think, is maybe not as important as it being done. We do that case by case. It has limited value for us as well in how we use it. But these are things that we can require to be part of conviction review process that a defendant would normally not be required to do. We're going to look at any evidence that the defense has. This is not a surprise process. I mean, we really have to know everything the other person is doing. And because it's such a long process, it's also really important that we keep the defense updated on what's happening on our end. I do believe that's essential to an effective conviction review unit is communication. Part of that is because a conviction review process does nothing to toll any statutes of limitations in Tennessee. So it is incredibly important that we keep the defense aware of what our progress is, how we're doing things, so they can make decisions with their client about other legal avenues they may want to pursue. Some CRUs do not allow other legal avenues to be pursued while there is a conviction review happening. Yes.
I have a question for you, just as you talk about this. We know there's not a conviction review unit in Memphis, and I think Nashville has the only conviction review unit in Tennessee. Is this a Southern phenomenon? Are there a lot of conviction review units in the South?
There are not. There are one or two in Georgia, and there's one in Tennessee. There's one in Missouri, although that's arguably not the South. This is, I wouldn't say it's necessarily a Northern phenomenon either, but it is certainly a larger city phenomenon. I mean, Philadelphia, Brooklyn, the Bronx, Manhattan, Dallas, Baltimore, those were among the first.
Progress, so to speak.
Right. I didn't want to say that, but
that's all right. How you say
there's also offices in Tampa and Orlando that are incredible offices. Frankly, Shelly Thibodeau in Florida was essential in us figuring out how to go forward and do things. And when we revised our CRU and did 2.0, we really reached out to those other units. It is an isolating endeavor. It is. When our unit started, there were only 25 in the country. When I took the job, there were about 75. Now there's about 105. And while that sounds like a lot, I'm sorry?
Across the nation.
Across the nation.
Okay, good.
And there are about 2,700 district attorney's offices. So we are still talking about less than 5% of DA's offices that have these. So even in terms of how do we do this, figuring out how to do this, we really rely on each other. I spend a lot of time on the phone with other CRU directors that have been doing this a while. I spend a lot of time on the phone with the Quattrone Center, who really has become kind of the think tank for CRUs and how they should work. We rely on the experience of other CRUs. And even among the 105 of us that exist, there's, I think, only maybe 30% of those that have had exonerations. And then even of those, a large percentage that have only had one. Now, again, I'm not being, you think about that. There's resources involved, first of all. There's triage involved. And some of our limitations, which I think is a question that'll come, is what are some of the limitations with a conviction review unit? The obvious one is resources. I mean, even the most committed offices are always battling budget, always. And again, we're battling the century of thought about whether or not this fits within a district attorney's office. So that's even furthers the battle. But beyond that, it's not as simple, and not to say that case origination is simple, not to say that the original cases when they come through DA's offices are simple, but when we get them, you can rest assured that there is evidence lost or misorganized, that witnesses are difficult to find, may not remember things, may have passed away. Certain police officers may be retired, have moved out of state. The challenges that we are going through is pretty incredible. And then we're also dealing with, and I say we more broadly, because frankly, I've been incredibly lucky in Nashville. I have just not experienced pushback in my office the way that I expected to. Not even the way that my boss, Glenn, prepared me for when I took the job. He asked me if I was prepared to be disliked by everyone, by the defense bar that I've worked with my whole career. If I was prepared to be distrusted by them because I've joined the district attorney's office and I now report to the elected district attorney, and by prosecutors internally who may have a belief that I'm some type of internal affairs going to undo the work that they've worked so hard to do. I have been very lucky in my office. I think that the culture shift there has just been going on for so many years that I have we've only received pushback by one prosecutor on a case that we've had. It was aggressive, and that person's no longer with our office. Every other prosecutor who has been on a case that we've had has been a professional. And I say that because one of the criticisms that CRUs get, the question is, how can you evaluate cases when the prosecutor who handled it is down the hall? How can you look at the cases of your colleagues? I would point to those critics to the defense bar, who have been engaging in peer review since the beginning of time. That's what post-conviction is. And as defense lawyers, we expect it. We expect that after a case happens, when there's a conviction, other lawyers are going to look at that case, evaluate it for what we could have done better, and file motions and put us in court to defend what we did or didn't do. It's part of the process. And I think the defense bar has recognized that not a single person is perfect. There is not one lawyer out there, no matter how good, that doesn't have something in a case that they feel like they could have done or should have done or might have done differently. Not one. Peer review is part of the process. It's normalized for defense lawyers. There's no reason this should not be normalized for prosecutors too. It's simply peer review. That's all it is. I am not out to villainize prosecutors. That's not part of what I do. I have been very clear with the attorneys in my office, and I mean this, that unless there is a pattern of intentional misconduct or something incredibly egregious, and in those cases, we will call it out, we'll put it in writing, we need to make clear that it's unacceptable. But when that doesn't exist, when we have mistake, when we have lack of information, when we have changing science, when we have oversight, I'm not out to villainize anyone. And if I can fix these wrongs without hurting a career, without villainizing a person, then I'm going to do that. Now, if there's no way to fix it without calling someone out, then we do what we have to do, because what's most important is a person who's innocent and has been convicted of a crime. And we're professionals and we're adults. But I just find that particular criticism to be insulting. I think it is insulting to licensed professionals who took an oath to seek justice, and that means admitting error. And I also want to be clear on that, is that while misconduct is certainly a factor, we know that. I mean, every longitudinal study of wrongful convictions shows that misconduct is a top 10 factor, whether it's by prosecutors, whether it's by police officers. But mistake doesn't equal misconduct, and misconduct doesn't always equal intention. And that's just a reality. The other reality that I have really been focusing our CRU on identifying and dealing with is bias. And that seems like such a trite thing, right? It seems very obtuse. It's really not. The bias that exists at every single stage of our system, the bias that exists that we deal with as a CRU, is really, to me, the number one factor in all wrongful convictions, because it creates a lens that you view evidence through. It creates a lens that you view people through. You may be a district attorney who is responsible for finding justice for the family of a dead child, or a rape victim. And the lens that alone can create for you, with that weight on your shoulders, shapes how you view evidence. And that's often outside of your control. How we come to the table, our own life experience, shapes how you view evidence. We had a case that was very recently publicized, Joyce, Watkins, and Charlie Dunn. And I'll circle back to why I can talk about that case, that we file our reports publicly. But one of the ways that I can demonstrate bias is in many of the discussions related to that case. There was a factor in that case where a child was staying with family members for basically a few weeks of a summer. Some members of my team found that incredibly odd. That was not part of their life experience. But for me, that's just what you did. All the kids got loaded up and went to grandma's house for the whole summer. There was nothing strange about that. There was nothing sinister. It wasn't indicative of anything. So the life experience we bring to the table really shapes how we view evidence. Beyond that, expectation bias, confirmation bias, tunnel vision, all of these things are such factors to deal with. This is the reason that me as the director don't meet with defendants until towards the end of a case, if at all. For that same reason, I don't meet with the family members of victims until we are nearing completion of our report. For the same reason, I don't want to create bias. Now, we do inform family members when we've put a case into full investigation. We assign a victim witness advocate who's a trained professional in our office. They meet with family members very quickly and explain to them the process that's happening. We give them an opportunity to have input, to weigh in with any documents or evidence they want us to consider. You know, they've been thinking about these cases for a long time as well. And we don't want them to feel blindsided by what might happen. And then our victim witness coordinator keeps them updated periodically on where things stand. But they do not meet with me, and they do not meet with whatever lead investigative attorney, if it's not me, until we are nearing completion of our report, because we do not want to be biased by the emotion of those meetings. We might really feel bad for that family. We might really like them. Same way with the defendant. I don't want to make a decision based on whether I like them or whether I believe what they're telling me when we meet. And for that same reason, it's very important that more than one set of eyes goes on these things. So if I'm the lead investigative attorney, then I will go through a lengthy investigation. It's incredibly thorough. We touch every piece of evidence in the case. We interview everyone we can interview, with two exceptions. We do not involve the attorney who prosecuted the case, and we do not involve any investigative law enforcement who were on the case, except to ask them specific questions that there's no other way to get answers to. Many times the prosecuting attorney doesn't even know we're looking at their cases. We do not want to put people on the defensive, and we don't want them to present us with their thoughts and feelings about a case. What happened in that case should be clear in the record. It should be clear in the file. And unless they've been out investigating a case for 10 years since it closed, they shouldn't have anything new to offer to the case. And again, this is all about preventing bias. I do want to take a breath and give time for any questions. I want to look for a second.
I had a few questions for you to try and flesh out some things, Sonny. And I guess the first thing is I know that you're in the CRU in Nashville. And just so folks understand, all of the cases that your unit reviews are strictly cases in Nashville, correct?
Yes.
Okay. And I heard you talking a bit about, I guess what I'll call sort of civil war that goes on between you and perhaps other prosecutors, because some may see you as sort of the police of the police, for lack of a better term. But with that, have you all had the opportunity to take a look at some cases that are part of General Funk's administration?
So here's the issue. We have certainly looked at cases where prosecutors are still in the office now under General Funk. We haven't ruled that out simply because they're in the office now. If we ruled out cases of prosecutors that are still in the office, we would be ruling out thousands and thousands of cases. But that's part of why I stay so separate from the rest of the office. But we do have to draw some conflict lines, because ultimately these decisions are up to General Funk. I mean, what I am is an investigative attorney, and I turn a report over to him. But the decision's not mine. The decision is General Funk's. He cannot make decisions on cases that he may have been involved in either a prosecutorial capacity or even in his prior career as a defense lawyer.
Sure.
So a few times a year, we may get a case, an application that may involve him at some level, even in the most minute. And above all else, we have to be trustworthy more than anything else. The community needs to trust us. They can't trust us if we're looking at cases that he handled or that I did. I was a defense lawyer before. So we do have to conflict off those cases, just off the top. And some of that we had to muddle through at the beginning to figure out. We do have a backup lawyer in the office that is handling a case right now that I was one in a succession of attorneys for someone, because I can't touch that case. It wouldn't have integrity. And it has to. So I stay completely out of that. But yes, there are cases we have to conflict off of entirely. When that happens, we will refer those cases to our Tennessee Innocence Project.
Okay, so there's a process in place. Super. Okay. Can you see the questions?
I can
really see any.
I can totally see the questions, but I do want to lean into the why real quick before we get to the full Q&A. Can you tell us a little bit more about why a conviction review unit is so important? I think William could probably tell us some of that too. But between William and Sonny, if y'all could just tell us, why is this important? Why is it needed?
Well, I'll say this, and this is from my experience in prison. The gist of the people that I met in prison were people of color and poor people. And when you think about the way the criminal justice system disproportionately affects people of color and poor people, in my opinion, it's a way of balancing out the system, because, again, district attorneys are humans and they're going to make errors. And I promise you that in those errors, a lot of people that are going to be affected are going to be people who are people of color and poor people. So that's my idea.
It's true. I mean, and the limitations of trying to prove your innocence while imprisoned, it's certainly a problem that in our system overall, CRUs or not, needs to be addressed, are those resources. But beyond that, one of the things that, I say a lot is that there is no person who has a harder time proving their innocence than an innocent person. And that is a reality. I mean, they may have no idea what happened. They may not know why this is happening to them. They might not understand enough of how they got into this position to form a defense at all. And for defense lawyers, reaching back into my brain for that period of time, that's often the scariest client to have, is a truly innocent client. That it's a myth that the innocent client is the easier one to represent. That is just 100% not true. But why a conviction review unit is so important, it's not, I don't want to insult the question. It's not that I think that's not a good question. I'm just not sure it's the right question, because it's not about why they're important. It's why they're essential. I mean, they should just already be there. We should be part of the process. And I would argue that the rules of professional responsibility require it. I would argue that the rules of professional responsibility have always required it. If the prosecuting body does not have a mechanism for self-accountability, then we have a gap in the system. If there is not an opportunity for the body that investigated the case, when they're faced with something new that would have changed their decision to charge a case, or would have changed their decision to take a case to jury, there has to be a process in place for us as that body who made those decisions to begin with to go to the court and go to the public and say, we were wrong, or we would not, or even not even that we were wrong, because sometimes it's not about that. Sometimes that charging decision, based on what we knew at the time, was absolutely the correct decision. But what we know has changed. The science has changed. We find a new witness. There's new DNA. There's a new fingerprint. Something we believe to be true, we now know is not true. How is it not essential that we, as the body who made the charging decision, can come back to court and say, we shouldn't have, or this was the wrong decision, or that we have lost confidence in that conviction? It has to be built into the process. And I would argue that not being built in the process is a glaring gap in our system to not be there. And like I said, I really don't even understand how it hasn't always been there, because for the defense bar, like I said, peer review has always been there. So someone at some point recognized that lawyers are human beings. Someone recognized that lawyers may not have had all the information, or may have had a bad day, or may have had something going on in their lives that affected their representation. Somewhere, someone put some safeguards in place for defendants to be able to come back to court with new science, for defendants to be able to come back to court with the dismantling of evidence that convicted them. It is nonsensical that the state should also not have those same mechanisms and safeguards in place. I mean, in my mind, that is a form of burden shifting. And we have what we are saying is an innocent person. And in Tennessee, we still say it's up to that innocent person to come to court and bear the burden of proving their innocence. And at least in our office, we have said no. We have said that when we believe someone is an innocent person, it is our burden to come to court and make that case.
Thank you so much. This is awesome, but we do have a lot of questions, which is really fun. I'm so glad that people are really excited by this and really interested. So I'm going to go ahead and ask you the first question, and I'm trying to get this right, and it may not be in the order that probably needs to flow, but we'll get it figured out. Kelly asked early on, and I think you touched upon it, but I thought maybe, Sonny, if you wanted to give a real bullet point answer to this one. I'm surprised that the CRU is part of the DA's office and not the public defenders. Why is that? And again, I think you answered a little bit, but if you don't mind kind of just doing a touchstone on that.
So again, a couple of things. One, we've got to talk resources, and public defender, well, I mean, really both sides, but we are constantly dealing in triage. I mean, for every 10 cases that are resolved, there's 100 more that come in, and public defenders have emergency situations in front of them. But rather than ask the question about who should be doing this, I argue we should all be doing this. And public defenders' offices do typically have appellate divisions, but they're fighting the state. The state is defending convictions in that aspect. It's still very much adversarial. What we have is what I've talked about before, without the court system. I mean, this is before. Remember that CRU is an extrajudicial process. This is not something that's happening through the court until our process is over. This is an internal process. And again, that access to information, if the public defender, now again, our office has an open file policy, but that is not the norm nationwide. It just isn't. And it's not the norm in any adversarial system. But if the public defender filed these motions, they would go to court. They might file discovery, which is even more limited in a post-conviction and appellate process. I mean, your rights to things are different. But they may still not have access to DA notes. They may not have access to police file. There may be items in other agency records that were simply not discoverable. And look, the proof is in the pudding here in Nashville, because in 3 cases off the top of my head, innocence was in those places. It was not in what was discoverable. In the Paul Garrett case, it lied in a report that had been in a file for 10 years that would have been work product under any rule. There is no one that would have gotten that under any request, public records discovery at all. I opened that file and it was sitting on top. And it was a report from another DA who 10 years earlier had said, we have the wrong person. That would not have come through any other process but an internal one. In the next case, in Joyce and Charlie's case, there was police records that not even the DA's office had, that just simply were never given to the DA's office from what we can tell. And it was in those reports that arguably there wasn't a legal avenue to get those reports either. But innocence, I mean, there were a lot of factors proving innocence in their cases, but some of the most critical were in those what we found in the police files. That's why the CRU is so important, is our access to information. And relating back to the Paul Garrett case again, that case, institutional memory was critical. I really had to be able to walk down the hall. I mean, literally walk down the hall and point at a sticky note and say, whose initials are these? And that was a field of information that opened up simply by being able to ask that question. Who is a defense attorney going to go ask that question? What hall are they going to walk down and say, how did we used to do this? Who approved these deals? How was this decision made? How were these requests made? How are these records kept? Is this work product? That kind of thing. This has to be internal. And it is an exercise in trust. I mean, it really is. And that is the most difficult thing. I talk to the defense bar as often as possible about this exercise of trust, because we have to trust each other to do this process. I also have to trust that they're not going to bring me cases that they do not believe they have actual innocence, because this is so different than the normal process. I have to believe that they are not hiding evidence from me that would be bad for their client. And we build that into the memo of understanding. Now, if CRU pulls out of a case, our memo of understanding says that there won't be any inferences drawn from that. There can be a lot of reasons that someone is not eligible for CRU review, or that an attorney might want to pull their lawyer out. So they have to trust that I'm not going to walk down the hallway and go, man, this person's guilty. But they also have to know, again, with the risks, that if we actually did find proof of someone's guilt, we're going to turn that over. I mean, that, we're not hiding evidence in our office. So this is an exercise in trust. It just is. But I firmly believe that the role of the defense lawyer is critical, but this work desperately has to involve internal investigation by the district attorney, or it will never be complete. You just can never guarantee to a defendant that they have seen everything and that they know everything about their case unless you have internal review and collaborative process with the DA's office.
Thank you. Now, William, I have like 8-9 questions for you. So I'm going to kind of throw them out. And then what I'm going to do, so that we don't go over time too much, is anything we don't get answered in the Q&A, I'm going to put it in the chat. And even after William and Sonny leave us as panelists, if you all don't mind looking in the chat, I'll put some of the questions in there, because there's quite a few again, and hopefully we can get some answers. Couple that are really powerful. Donna asked, Dr. Arnold, in listening to you speak of your freedom, I'm wondering, at what point did you actually believe you were truly free? And I think that's such an important question. But in that same token, Melissa asked, the way that William talks about humanity, I wonder if he has come to a place of forgiveness over this nightmare. And then, so there's a lot around that. And then finally, there's so many of these questions, so we will get into it, I promise. But the other one was, what did it feel like when you found out you had a way to clear your name using the CRU? Okay. I know that's a lot, William. Sorry.
Yeah. Thanks, Janice. Thanks. So I'm thinking about some words I'm hearing: freedom, forgiveness, humanity. A lot of that just starts with who you are. Thankfully, I was a person who believed in people beforehand. And so even after, this experience, it's allowed me to believe in people again to some degree. I mean, I kind of have this saying, or I don't trust you, but I believe in you. So I'll let you figure out how that works. But this experience allowed me to see a different side of humanity. It allowed me to see people really giving and people helping out. So with that has allowed me to have some sort of a restoration, if you will, in humanity. Freedom is such a broad thing. Physically, I know that I'm free from that place, but there's nothing that's ever going to replace the 6 years and the 9 months that I was there. There's nothing that's going to replace the births, the graduations, the Mother's Days, the funerals, the Father's Days, the retirement parties that I was unable to attend and will never be able to attend. I mean, at the end of the day, I went in as a 41-year-old man and came out as a 48-year-old ex-con, for lack of a better term. And so there's nothing that's ever going to fully restore a sense of total freedom, because that's just a part of who I am now. It's a part of my identity. which, has, its benefits to some degree because it allows me to stay vigilant, for lack of a better term. Did that answer all the questions that you threw at me, Janice, or do you have more?
I think that answered the ones that I threw at you, but there are more, so I will be putting them in the chat. Let me get to another question that we asked. I think it's kind of an interesting question on Sonny, you might want to hit this one, on who can initiate a CRU program. What's that process? How does that happen?
The elected DA can initiate a CRU. Now there are some questions beyond that are out of my depth, but I believe the elected DA can simply say, I want a CRU and set up a unit. They have broad discretion of how they run their offices in this state. And the next thing that should happen if someone sets up a CRU and is doing it honestly is an analysis of other CRUs. The ones that you want to model yourself after and why. For us, we looked to CRUs that had been around for a while that had proven success. And success, again, is not only measured in the number of exonerations. It's also measured in how much the community trusts what you're doing, what the defense bar has to say about your unit, how your unit is working towards prevention of wrongful convictions along with remedy. And that can be challenging, again, because of resources. But an elected DA has to say, I want to do this and mean it. And that's really, and then they have to commit to it after that. And that commitment takes study of other CRUs. And then it just takes doing it, setting it up. I think that in Nashville, what was discovered is something other CRUs have is that I do believe it's important to have someone with defense experience doing this work. Again, no disrespect to district attorneys. I believe that there are some incredible CRUs being run by former prosecutors, but there is, again, relationships with the defense bar and a different perspective that comes with being a DA. But ultimately, even that is about community trust. If you put a career prosecutor into the job of reviewing cases of their colleagues that they've had for 20 years, the community is going to have a more difficult time accepting that work is being done effectively.
Sonny, I love your answer, but I disagree a bit. And you said that an elected district attorney can initiate a conviction review. And I think it starts with the people. I think it starts with the people who elect that district attorney and who elect a district attorney who understands the importance of a conviction review unit, who perhaps runs on the basis of having a conviction review unit, and who keeps their word when they become district attorneys. So I think it starts, folks, with those registered voters who want progress, who want something better for their communities, who want something better for their cities. And that's where the idea of a conviction review unit starts.
I stand corrected. I completely agree. And we have seen that. This is going to sound like a brag at it, and maybe it is. But one of the proudest moments of my career was the Nashville Scene last year, which is our number one alternative newspaper. I mean, the Tennessean's our number one newspaper, but the second is the Nashville Scene. And the Nashville Scene voted the Nashville CRU as Nashville's best kept promise. And I mean, think about that. Think about how that felt for our office and for me as its director and for Glenn as its elected DA. Nashville loves the CRU. They respect what we're doing. We've worked hard to earn community trust. And I would like to believe that if at some point another entity tried to close it, that Nashville as a city wouldn't have it.
Go Nashville.
That is awesome. And they're right on the money. And I am so grateful for the work that you're doing, Sonny, over there. I'm grateful for Williams to sharing his story. And I'm grateful for your time and sharing, but you're not off the hook. Even when you leave here, I am literally posting. There you go. You see all those questions in there? Some are for Sonny and some are for William. So,
may I interrupt you for one thing, because there is one very quick but incredibly important point that I can't even believe that I forgot. One more reason that this is not just important but critical. Although I mean what I said about we create new victims of wrongfully convicted people, there's a whole nother side to this. we are victimizing families and people who've been victims of crime if we don't find the right people who have victimized them. And that, again, how can anyone argue that that's not the job of a district attorney's office to not just convict people, but the right people? So even those who would argue that defendants have the Innocence Project or have the Public Defender's Office or have the defense bar, the victims of these crimes are still on us. That's on us. And we owe them the duty of making sure the right people are held accountable. That's all I have to say about that.
No, I think you're absolutely right. And I just want to say thank you again. And again, there's a whole bunch of questions if you if you have time to look at them. I can't thank you enough. Ernie, you may want to say some thank you. I know you think you're not on the screen, but you totally are. But I want to say thank you.
Okay. Well, thank you so much, guys. I really appreciate you, Sonny. I am so awed and impressed with you and just the talent and the skills that you bring to this great work. And I can't say more about William because I don't know why he's not angry. You know, 7 years of his life and freedom and all that taken from him, and he's not having to rebuild. I love you, boy. I love you, man.
Thank you, Aaron. Love you too, man.
Thank you all for having us. I really appreciate it. Any opportunity to talk about this work, it's a movement and it's incredibly important.
Good, thank you. And now stay tuned. We're not done. I just want to be real clear. We got work to do. And so you can hear about the exciting work we're going to do. I'm going to let Cetria turn her camera on. And again, thank you, Sonny. Thank you, William.
Thank you.
You are muted, Cetria.
Thank you. And thank you again, Director Eaton, and thank you again, Dr. Arnold. Thank you all so much for this powerful information that we have just received. And also, I want to thank you, Dr. Arnold, for sharing your life experiences. And all of this builds the foundation for why it's necessary for us to have a conviction review unit in Shelby County. And I just want to ask you, as we have heard the information and we've heard the experiences of Dr. Arnold, have you ever been wrongfully convicted of anything, whether you were wrongfully convicted or accused of something, maybe by a family member, maybe by a friend or a husband or a girlfriend, wife, boyfriend? How did it make you feel? Just the fact that they did not believe what you said or thought you did something that you didn't do. Did it make you mad? Maybe it made you angry. And how did you feel that you couldn't even prove that what they were saying was wrong because they would not believe you? Think about those that not only are mad or angered, but have been locked up, have lost time, and even those that have lost life because they were wrongfully convicted. So I stand with MICAH. I want each of you to jump into the fight and work with us. And why do I do this work? Why do I do this work? I do this work for my daughter, who, when she left college one night, driving a car that I had bought her, she was pulled over, tags were ran, told that she was in a car that did not belong to her by the white officer that stopped her. Not only was she told that the car did not belong to her, he insisted upon her signing a ticket for something she did not do. I praise God that she had turned her microphone on her phone so that I could hear the interaction. When she refused to sign the ticket, he grabbed her by her wrist, threatening to pull her out of the window of the car. I was so afraid for her life. I just remember being at work, running through the office, screaming, "Sign the ticket, sign the ticket. They may beat you or kill you, sign the ticket." My daughter was one of the blessed ones. She had to sign the ticket for something she did not do, but she came home with her life. My other daughter, leaving a coffee shop one evening, someone turned in, a white driver turned in, almost hitting her car. And I lift the brace up because it's important. when you're being profiled. Turned in, almost hitting our car. She blew her horn, did not yell expletives, did not curse anyone out, just blew her horn. She was pulled over by a white officer telling her what she did was against the law. They badgered her and her then boyfriend, referring to them as you people several times. My daughter, realizing that she had precious cargo with her. No, not a baby, but a black diamond, a black man. She did everything she could not to escalate the situation because she knew that escalating it could mean that they could have been thrown in jail or could have not come back alive. So I'm thankful that both of my daughters, neither one were incarcerated, even though they were profiled. But what about those that's not their story? We thank you, Dr. William, for sharing your story. He shared that 6 years of his life that he could not get back. So this is why, and I thank you for lifting it up, Director Eaton, that a conviction review unit is not only desired, but it's necessary. It's needed. General Glenn Funk, whose office established the CRU in Davidson County, said that establishing a conviction review unit serves the goal of implementing best practices in the criminal justice system. The Nashville community deserves a prosecutor's office that will seriously and conscientiously consider claims of actual innocence where newly discovered evidence exists. This office is committed to supporting victims by vigorously prosecution while at the same time ensuring that the actual perpetrator is prosecuted, convicted, and sentenced, but that those that are innocent are maintain their innocence. It says that the work of our conviction review unit in Nashville has greatly increased trust in our office and the work that we do. What do you think? Doesn't Shelby County not only deserve a conviction review unit, but in the words of Director Eaton, we need one. It's necessary. So if you think that Shelby County deserves a conviction review unit, how do we get a conviction review unit? I thank you for the dialogue between Dr. Arnold and Director Eaton when it was said that a DA, a DA's office can start this process, can initiate this process. But he clapped back. He said, no, it's the people in the community when we vote. Look, I want you to look at the statistics that are on the screen. It's when we vote. In our last county election, only 150,000 Shelby Countyans voted. Now, if you think about the fact that there are about 700,000 Shelby Countyans over the age of 18, there are 500,000 Shelby Countyans that are registered to vote, but only 150,000 voted. When we vote, it matters. When we vote, it matters. We can change this. We must change this. We must seek justice by voting local. So tonight, it's time for our action. You've heard all of this good information, and I know you're ready. You're fired up. You want to know, what can I do next? Well, right now, we're going to take the Seeking Justice Voter Pledge. So first of all, this is what I want you to do. I want you to type into your search bar the bit.ly, bit.ly/Seek Justice Vote Local, or scan the QR code. Here's my phone. I'm getting ready to join you. We're going to do this together. Yes, because that's how we organize power, when we organize people, and we're organizing people right now on this platform. So we're going to do it together. So what I want you to do, again, is either scan the QR code, or you can type it into your search bar. It's bit.ly. I'm doing it too, /Seek Justice Vote Local, and I want you to take the voter pledge. Are you doing it with me, Paige? If you can see as people are doing it, I want you, if you don't mind, will you drop Dunn into the chat when you've done it? Oh, I have one. Janice, all right, Janice, she beat everybody. She's got Dunn. Come on, if you're doing it with us, come on. Come on. Come on. I'm doing it too. I don't know if you can see my phone, but I'm doing it too. All right. And it says, become a seeking justice voter. I pledge to be a seeking justice voter in May, August, and November 22. And that's listing the vital upcoming elections that we must vote in. It's when we put officials in place and we say to them, this is what we need. They're working for us. All right. I did it. As you take the pledge, are you doing it? How many more? How many have taken the pledge? Can you tell me? Let's see. Justin Howerton said, done. Thank you, Justin. Come on. Who else is with us on taking the pledge? I want you to know that as you take the pledge, Fabio Powell, Daniel Keel, done. Come on. Keep it coming in. Keep it coming. Keep it coming. So next, the second part. I want you right now to text 5 family members and friends. It can be more, because I know some of you have thousands of friends and hundreds of friends, but text at least 5 members and friends tonight to take the pledge. I have family members and friends that are watching. I'm going to text them now to take the pledge. All right? And you can share the information with them. Are you doing it? Are you texting them to take the pledge? Well, why don't you put Dunn in the chat once you text those 5 to take the pledge? Come on. Let me know. I want to see it. Put Dunn. Let me know that you did it. Come on. This is important. We cannot sleep on this. We cannot sleep on this. It's when the people, when we speak, when we say no more, when we say we won't take this anymore, when we make our voices heard collectively. Thank you so much for listening and for being here. I'm going to hand it off to my friend. Continue to read. Oh, I almost forgot something. I'm sorry. If you took the pledge and you're wanting to know what else to do next, you took the pledge, you text 5 friends. These are the next steps. Community read, you'll get information. The book called Charge by Emily Bazelon, writing postcard to voters. Phone, text banking. We're going to do all of this door-to-door canvassing on Saturday, starting this Saturday. Candidate forum. So there is work to be done. We need each of you, and we thank each of you. I want to hand it over to my brother, Pastor Fred Morton. Thank you. Pastor Fred, are you there?
Fred's having a little difficulty with his sound, so, oh, there we go.
There he is. All right, awesome.
Hello. This is Fred. As many of you have heard time and again, whenever MICAH does something, we like to evaluate it. And so we're going to evaluate this event very quickly tonight. As some would say, quick and dirty, but that's probably not the appropriate kind of language. But we have heard a lot tonight. And we all know that our justice system is imperfect. But the imperfections that we have work to the extreme disadvantage to a certain section of people who happen to be poor and of color. And we have heard one remedy that's been raised up tonight. So I want you to think about something that you heard that has kind of rattled your brain or stricken your heart or hit you in the gut. And I want you to come up with a one-word feeling, thought, or notion to put in the chat, and we're going to go through this real quickly. It'll just take a few moments to go. I'll just lift up a few that are here. So anything that came to your mind or to your heart or hit you in the gut about what has been said tonight, just share it. Determined, motivated, that's good. Amazed, accountability, angry, knowledgeable, power, action. Good. That's great, Will. Justice, moved. All right. Thank you very much for that candid response to something that's truly been moving. Now, to close us out tonight, we'll turn to Rabbi Dreyfus, who will close us. Rabbi Dreyfus?
Hi, everyone. I'm Rabbi Jeff Dreyfus with Temple Israel here in Memphis. And before I begin the prayer, I just want to share with you how honored I am to be part of this group and part of this panel for people who are doing such special, such important, such holy work. Thank you to all of our panelists and all of the MICAH folks from all walks of life who are working to solve this problem. This coming Shabbat, Jewish communities around the world begin reading the book of Leviticus. In the section of Leviticus known as the Holiness Code, God instructs the Israelites for how to become a holy people. God commands in the Hebrew, Lo ta'asu evel b'mishpat, lo tisa pnei dal, v'lo tehadar pnei gadol, betzedek tishpot amitecha. You shall not render an unfair decision. Do not favor the poor or show deference to the rich. Judge your kin with justice. For far too long, our criminal justice system has not reflected that true tzedek, that true sense of justice, which God demands of us. For far too long, our system has favored the rich and the privileged, people of one race over another. Yet in the words of Brian Stevenson, you ultimately judge the civility of a society not by how it treats the rich, the powerful, the protected, and the highly esteemed, but by how it treats the poor, the disfavored, and the disadvantaged. Far too many poor and disadvantaged and disfavored innocents languish behind bars. Our spiritual ancestor Joseph, he too was falsely imprisoned. He was locked away and forgotten, and yet God remained with him in that pit. God did not forget him. And yet this world, unfortunately, this world that God created is not one full of tzedek, full of justice. So it is up to us to be God's partner, to make that dream come true. God needs our help. So let us continue this work so that together we may truly fulfill God's command. Kedoshim Tihiyu. Through this pursuit of justice, may we truly become a holy people. And together we can say, Amen.
I want to thank everyone for being here tonight. The slides continue to scroll. We continue to ask you to join on and be a Seek Justice local voter, take the pledge, share with others, and wrestle with what you heard tonight. We had someone ask us, why don't we have one? I think it was Bernice. Why don't we have a CRU in Shelby County? I think it's a great question. Let's make sure that we let everyone know Shelby County deserves a conviction review unit of its own. Thanks for coming tonight. Thank you to all our guests and our speakers. And I want to say a special thank you to Liza Lefko, who helped chair this town hall and did a fantastic job. So again, thank you to everyone who worked so hard on this. And thank you all for being here. Good night.